Starts.
Yeah. Yeah. Good evening, members. Welcome to yet another very interesting session. Today the topic is provisions on application under section 119 to CBDT and application under section 264. To address this, we have Sri Ajay R. Singh, who is an advocate practicing at Mumbai. Sri Ajay R. Singh is a graduate and also an LLM from Mumbai University. He joined the bar in August 2000, and since then he is in practice in the profession of law. He is practicing as a counsel before Supreme Court, High Court, Appellate Tribunal, Settlement Commission, Commissioner Appeals, and also appearing before Metropolitan Magistrate Court in tax prosecution cases. His main areas of practice include domestic taxation, search and survey matters, international taxation, transfer pricing and prosecution relating to taxation matters. He specialized in drafting and appearing in writ petitions and appeal before High Court and special petition before Supreme Court, drafting consulting in the areas of real estate transactions as well. He is filed and associated with various public interest litigations on issues concerning tax professions, namely National Tax Tribunal petition, fringe benefit taxation, to name a few. He's also authored books on reassessment law, procedures and practice, and is co-authored in various books on taxation and allied laws on various subjects, namely interpretation of taxation statutes, etc. He's been a regular faculty addressing and giving lectures on topics on papers at various professional bodies across India, such as Federation of Tax Practice, of Tax Consultants, Institute of Chartered Accountants of India, to name a few. He's very actively taking part in various social organizations. Has been a president of Chamber of Tax Practice for the year 2018. Been a joint honorary secretary of ICAI Bar Association Mumbai, and has also been a joint assistant editor of AIFTP Journal Chamber Consultant. It is very brief. Right. Friends, I would like to advocate Ajay R. Singh to address the gathering. In fact, friends, he has given his material. I think so members can raise their questions in the query box, and as and when he completes first part of it, maybe he'll address the question, or you can also ask the questions session. May I request Ajay R. Singh to begin.
Sir, you can start.
Yes.
Yeah, you can please.
Yeah. Thank you, Naresh ji, for the warm welcome, and other office bearers also who are interacting with me for quite some time for this lecture. It is indeed a great opportunity for me to speak before this forum. My voice is clear. I hope I am audible.
Yes, you're audible and visible, sir. Thank you.
Thank you so much. Because of various restrictions, now we have to address through webinars. Otherwise, these programs used to have a physical interaction, but nonetheless, the process of learning should go on. And the topic which has been assigned to me is the provisions of section 264 and section 119. Basically, it is an opportunity to go through these provisions. Normally in our day-to-day practice, we don't come across these provisions, and many a times we see that these are the provisions just on the statute, but the application is not there. But to me, I have seen that this is really provisions which one can say that these are the benevolent provisions under the Income Tax Act and has been provided by the legislature simple remedies in the cases where the other provisions of the act fails to give this remedy to an SSC, and especially to a genuine SSC who due to various circumstances is not able to get his claim put up before the authorities, income tax authorities more particularly. Just to give a brief background before we go on the provision, we need to understand the concept, the idea behind these provisions. So, friends, income tax itself has a lot of provisions which gives you the department as well as to an SSC remedies against any demand, any action of the authorities. We have appeal provisions, we have rectification provisions where there is a incorrect or there is a mistake in the order. We have revisional provision for the commissioner to exercise under 263 where then order is passed by the department is erroneous or prejudicial to the interest of the revenue. So we have appeal provisions. So we have a lot of other provision which gives a remedy to the department as well as the SSC in certain circumstances. But let's take a case where the claim is not made by the SSC itself in the return. In such a situation, can he file an appeal? Or let's take a case where his claim is barred by limitation. He is not able to fulfill a certain conditions provided under the section due to certain other issues. In such circumstances, where he can go. So these are the provisions which is brought in by the legislature to remedy such a wrong and to address such a rights of an SSC. We also need to understand that our Income Tax Act, the provision itself are so complicated that even a seasoned lawyer at times are not able to interpret the provision this way or the other way. We have sections, we have subsections, we have explanations, we have proviso to that. Further to complicate the things, we have circulars, notifications. If we have done with all these things and we have understood the provision, then suddenly legislature feels that this provision is not required and they delete or they amend and bring up some new provision. So we have seen in past so many provisions who have been just amended just to overcome the interpretation given by the courts and tribunals. And you cannot decide one way or the other. Take a latest example, which is there, the issue of freebies to be provided to doctors. The tribunal had various tribunal across the country had decided this issue in favor of the SSC, but there is an amendment to that effect which is brought in, as well as there is now a recent decision of Supreme Court where the decision has been overruled and it has given a different interpretation. So the provisions are not so simple. The tax provisions are not so simple. Courts and tribunals, as time again has said, that the tax provisions are complicated, and at times it is very difficult to understand what is the correct application or interpretation of provision. So there might be a possibility that an SSC many times miss to raise his claim correctly in accordance with law in his return of income. We also need to understand, when we are dealing with these two provisions, why the courts will come to the rescue of the SSC or why this provision has been brought in. We need to understand Article 265 of the Constitution, which says that the taxes has to be paid or collected by the authorities only in accordance with law. If any taxes, even 1 rupee, has been paid by the SSC and it is not required to be done, the department cannot keep it on the ground that, look, you have yourself paid that. Similarly, if they have collected some taxes from the SSC and it comes out that at a later stage that this collection is not in accordance with the provision of law, this particular articles come to the rescue of an SSC, and SSC can claim the said amount back. And there has to be some remedy for it. And these are the few provisions which helps in certain circumstances, fulfilling certain conditions, to make their claim, to raise their grievance before the authorities. And this is something which the legislature had thought while enacting this provision. And we will go through various other the provision and the conditions what are required to be fulfilled, and how courts have looked into all this provision and given the interpretation. I will take up first section 264. So basically section 264, if we read, is that in case of any order other than an order to which section 263 applies, passed by any subordinate authority, the commissioner or an SSC can approach under section 264 and request the department to revise the same. Normally, I have not come across a situation where the commissioner or the department has exercised 264. It is always, if they want to exercise revisional, they exercise 263, and that too only against an SSC. But section 264 is an provision which can be exercised by the department or by the SSC if any order is passed, to pass such order which is not prejudicial to the SSC. So they can decide this matter. If I make an application under 264 to make a claim, they can reject my application, but they cannot decide against or be adverse to an SSC. For example, if you go in appeal, there are provision of enhancement. The commissioner appeals may not give you a relief. At the same time, he can also have a power of enhancement. But here, if you will see under section 264, the provisions is such frame that the authority who is deciding your application cannot be prejudicial to you. So this provision under section 264, which is there, one needs to understand that this is not something which is a appellate forum. It is not a forum where you can file an appeal and argue a matter as if you are in appeal. It is basically a provision where it provides that, take a situation where the limitation period has expired for filing an appeal, and you have a very genuine clear-cut case. Here you can approach the commissioner by filing an application under section 264. Now it will be a matter of fact, and each case it will depend that whether you should go before a appellate forum or you should go to a route of under section 264. It is not a straight jacket formula where you can take a decision that yes, I will against this, we can go in 264 and not in let's not go in an appeal. So it will depend upon facts of each case to take a decision whether I should go to the appellate route, or I should go to the revisionary route under section 264. Because you need to also understand that when I go to an appellate route, there is a remedy of further appeal which is provided against the CIT appeals order. But when an order is passed under section 264, that order is not appealable. The only remedy against that order is to go to the High Court in a writ petition under Article 226. So these are the few things which one has to keep in mind before he decides a particular forum where he has to go against a order. Also, we need to understand that this particular application which is required to be made has to be made within a period of 1 year from the date on which the impugned order has been communicated to you. So if any order has been passed, if any action has been taken against that order, you may go in on 264 before the commissioner by making an application within a period of 1 year. This 1 year, again, the section also provides that even if an application is made beyond the period of 1 year, application for condonation of delay can be made, and the SSC has to make out a case why there was a delay, and the commissioner has the power to condone the same and to admit such application and decide the application on merits of case. So this power is also there before the commissioner, which has to be exercised in a judicial way. He has to give a hearing. So there is the principle of natural justice which is embedded in this particular provision. As I said, it doesn't have the trappings of an appellate forum, but yes, the powers are given very wide. They can look into the records, they can call for the records, they can call for reports, and thereafter they can decide the matter and pass such order as they may think fit. So the provisions are quite wide. The powers are given to the commissioner to decide these applications are also quite wide. There are certain limitations which is there in this. One is the time period, which I have explained. There are another aspect which is one you need to keep in mind. Subsection 4 of section 264 provides that in case you have already exercised a remedy by way of an appeal before the CIT appeals, then you cannot take this particular route. You cannot come back and say, no, the CIT appeal, I had taken this route, now I want to change this and I want to go to 264. Now, once you have filed an appeal, and if the appeal has not been decided for any reason and you withdraw the appeal, then yes, this limitation will not come in your way. You can still go. But once your appeal has been filed and it has been adjudicated by the Commissioner Appeals, thereafter you cannot say that, okay, fine, I will go against this route of going to 264. You cannot choose that route. If any appeal is pending before the ITAT or something, again this particular remedy, the same principle applies. You cannot exercise this remedy simultaneously. In the same way, if you exercise 264 and for any reason the commissioner decides your appeal, your application one way or the other, you cannot come back and say that, no, I will take the appeal route once again and try the other remedy once again. No, these are two different remedies to be exercised by the SSC. You cannot, it doesn't overlap each other. You cannot take one route, come back and decide to take the another route. So that cannot be done. So therefore it is very important that before you exercise this remedy, you have to weigh your facts, other circumstances and condition, and thereafter you have to decide which route you need to follow. As I said, that the decision which have been taken by the commissioner will be binding on the authority as well as the SSC. The SSC can certainly challenge that and go in a writ before under 226 before the High Court. So to summarize this, the scope of revisioner jurisdiction which is there, the order should have been passed by an authority which is subordinate to the commissioner. It can be any order. So if there is an order under section 179, for instance, which is passed by the officer for the recovery against the directors, if this order is passed, you can go in 264. You can challenge that before 264. The second is this: the power under 264 has to be exercised within a period of 1 year from the date on which the impugned order has been communicated to the SSC. The time limit is 1 year for the commissioner. They can also suo motu exercise, as well as for the SSC for 1 year from the date of receipt. Belated application, if it is filed, it can be done so by filing a condonation application. The SSC is required to show sufficient reason, cause for such delay, and it has to be explained. The commissioner has power to condone the delay and admit the application and decide the application on merits. Revisional jurisdiction cannot be exercised if an appeal is pending. Once a CIT appeal or tribunal has exercised its jurisdiction on the subject matter, then the revision under section 264 comes to an end and you cannot exercise such particular remedy. No order can be passed under this section which is prejudicial to the SSC. So this is a very important provision where it gives that no order can be passed under this section which is prejudicial to an SSC. So there were certain instances and cases which are there where just because 264 was rejected, the SSC had challenged before the court and said, look, the commissioner has passed an order rejecting my application and therefore this is prejudicial to the interest of the SSC. The court have interpreted this provision and they have said merely because the commissioner has rejected your application, it doesn't mean that it is prejudicial to the interest of the SSC. The term prejudicial to the interest of the SSC in this particular provision has to understand that something that is not the SSC, there is an adverse effect on the SSE by coming into the appellate forum. One second. So the revisional order again under 264 is not appealable. The only once the order is passed, the only remedy left with an SSE is to challenge it before the High Court in the writ jurisdiction. For exercise the power under 264, there is no requirement of payment of any fees. The application also, there is no format, any standard format of filing any application. But basically, when you draft an application under section 264, there are few conditions as per the provision which you are required to fulfill, which you have to come out your facts of your case, what wrong has been done. You have to put that, the necessary documents on which you are relying or your case is based, that documents is required to be filed. You have to keep in mind that you cannot file additional evidence or new evidence without the permission of the commissioner, or in case you want to rely on some external document, you have to mention so in your application before the commissioner. Though the commissioner has a very wide power to call for reports and to look into the records also, but one should see that your application is self-sufficient, the facts is clear. You have to mention that the conditions as required under the section has been met, and you have to explain your case and the relief what you are praying for. There were certain issues which had come, that the expression what is mentioned, order, which is mentioned that any order. So can section or an intimation which is passed under 143(1), can it be said to be an order, and can a revision application is maintainable against 143(1) intimation? The courts have looked into this provision, and they have said that when the term any order is there, it includes 143(1) also. So maybe let's take a case where a return has been filed and the return has been processed under 143(1). In such a situation also, an SSE is aggrieved by the order. Maybe there is some claim which has been missed to be raised by the SSE in its return, or he has wrongly offered certain income for taxation. In such a situation also, the SSE can file an application under section 264 and go before the commissioner. So even if there, so the conclusion comes from this, that even in a case where there is a mistake which has been committed by an SSE himself while filing the return or making a claim before the authorities, in such a situation also you can exercise this remedy under section 264 and make a claim before the commissioner under this particular provision. Various high courts have decided this particular issue and in the favor of the SSE. At this juncture, you should also be reminded about the circular of 1955, 11th April 1955, circular number 14, which was way back in 1955. The department, the CBDT, had issued this circular, wherein it was mentioned that in a cases where the SSE has a genuine claim and maybe he has missed that claim to be raised, it is the duty of the officer to inform the SSE and to look into that claim and allow that claim. It is not that the department should take the benefit of the ignorance of an SSE and deny a legitimate claim which the SSE is otherwise entitled under the provision of the Act. So the principle which is there behind this circular, we find the same principle is there in this particular provision also. And that is how the court also looks at this particular provision. I have also explained you how the term prejudicial order is has to be looked into it. The courts have always explained this. Prejudicial doesn't mean that merely because an order has been rejected by the commissioner, it has to be treated as prejudicial. The term also used many dispute is their records. What is the records? What records the commissioner can call? So basically, all the assessment records which are there, that assessment records can be called upon by the assessing officer in order to verify the claim of the SSE, to inspect, to look into the claim. The commissioner also can direct and make inquiries the way he deems fit, and can ask the assessing officer to submit a report in this behalf, and on that basis of that he can decide. So basically the powers conferred under section 264 to the commissioner is to do justice and to prevent miscarriage of justice being rendered. So keeping that factor in mind, even if a new evidence is there to be produced before the authorities, the commissioner powers are so wide enough to look into those records and related proceedings. So in case of 394 ITR page 247, the Madras High Court has held that the records includes all records relating to any proceedings, and commissioner has power to entertain the claim. So the powers of the commissioner under section 264 has been interpreted by the courts that the powers are so wide that the commissioner can call for the records and look into those claims. So as far as I explained, the powers also are quite wide, and the commissioner can look into even the new evidence, call the reports from the officer, call for the records of the officer. Just clarification I will like to add. I have explained that the filing fees is in this petition will be required. A 500 rupees filing fees will be required to be paid in this, and the format of there is no format. A normal format, you can file an application enclosing the impugned order and the documents which is required to be annexed along with the application. It is required that you file application in 2 sets, because 1 set remains with the commissioner and the 1 set is used to be forwarded to the assessing officer for calling a report. So it is always better that you make an application in 2 sets to be filed before the commissioner. As I said, that principle of natural justice is embedded in this section, and therefore the commissioner has to pass an order, a speaking order. He cannot pass a non-speaking order or an order which is without any reasons. He has to deal with your application, the documents which you have annexed, and thereafter decide your claim this way or the other way, and he has to pass a speaking order in that effect. If the orders are not a speaking order, it's a cryptic order, not dealing with your contentions, not dealing with your documents, you can always challenge such an order before the higher forum, before the High Court. And there are various decisions where the courts have set aside such an orders passed by the authorities under section 264 if those are not a speaking order or it's not dealing with the contentions and documents of the SSC. Now there is also a provision which is being added under section 264 subsection 6. So this subsection basically says also that the order, the application which has been filed under revision under section 264, an order shall be passed within a period of 1 year from the end of the financial year in which such application has been made. So basically the word is shall pass such an order. So the commissioner are required to deal with the application within a period of 1 year and pass such order as it deems fit within a period, such period of 1 year. So one can also, as I said, that subject to an appeal, the provision also required that any order which is subject matter of an appeal, that is not subject to the jurisdiction under 264, but if the appeal has not been decided on merits, it has been rejected for some limitation period or it is not maintainable, such an order will not come into the way of an SSC to make an application under section 264. So in such type of cases also SSC can file an application. This position was clarified also by way of a circular number 367 dated 26th July 1983, which is also reported in 144 ITR page 19 statute portion, where they had explained what is a subject matter of an appeal, and they have decided that unless and until an appeal has been decided, that cannot be said that the order was subject to an appeal. Or take an instance where an appeal has been withdrawn by the SSC, it cannot be said that the order is passed on merits and it is a subject to an appeal. And such a situation, application under section 264 will lie. So I will give you some instance also where an application under section 264 has been made and the courts have upheld that. So where a return is rejected as a belated without application of mine, here it is a case where the 264 can be filed, where certain items of income has wrongly been offered for tax. For example, just to give you a very simple example, an SSC has wrongly, while computing its income, has wrongly offered a particular income which is exempt or which is not liable to be taxed, and he has paid the tax and the return has been accepted under 143(3). There is no dispute and it has been accepted, and later on the SSC finds that he has wrongly offered this particular income to tax and it was not required to offer this income to tax. In such a situation, what he can do? In such a situation also, the courts have taken a view that they can file a 264 application and can make an application before the commissioner stating that this particular income was not required to be offered, but for any reason by its own mistake it has offered to tax, and in view of article 265 this income is not liable to be taxed, and therefore the taxes collected or paid by the SSC voluntarily also is required to be returned. So such type of claim is also maintainable. Let's take a case where an appeal is time barred and you have not filed an appeal against an order. In such a case also, the SSC can choose to file a 264 application and move before the concerned commissioner raising its claim. Let's take another example where an SSC has missed to claim certain deductions, though all the relevant data, information, etc. were on record, but the SSC has just missed to raise the claim. In such a situation also, the courts have taken a view that you can come in 264 and the courts have the commissioner can look into that claim and can direct the SSC to allow such claim if all the other conditions are required to fulfill. Friends, again I will say that while you are exercising this, you have to weigh your weight. What are the facts of your case? As I said, that 264 is not a remedy by way of an appeal, and it is a different remedy where your regular remedy you are not able to exercise your regular remedy. In such type of situation, you can exercise this 264. It comes to your rescue. So while exercising, you have to take a call that what sort of your claim is there, what sort of evidence is required. Is it a clear-cut case and it is merely because of limitation period or no remedy which is available to an SSC at that point of time, and therefore you should decide which route you have to choose. So some other examples are there where then SSC has challenged the order of assessing officer on basis of some decision of a court or Supreme Court or some higher court which is there, and the SSC initially has not challenged that order, but later on it comes to know, no, now there is an order in favor of the SSC. There is some Supreme Court or the jurisdictional high court which is there now in the favor of SSC, and now your claim is allowable. In such a situation also, you can take the benefit of those decisions, file an application under section 264 and approach the commissioner also under this provision. So if any income has wrongly been offered, you can still go. So revision petition is also a matter of where it falls. For example, any schemes have been there and you are not able to access, some immunity is required to be given against penalty or something, and the assessing officer has not exercised. You can choose to go to commissioner under section 264. So the courts have if after the 264 order has passed, and as I said, the remedy is available under 264, how courts have looking into this matters. So in which cases the courts will interfere and will allow the relief to an SSC, or will interfere to set aside the order passed by the commissioner. So for example, a case, as I said, that the commissioner has to pass a speaking order. He has to deal with your contentions, your arguments, your evidence, what you have filed. So if an order is passed which is a non-speaking order, non-reasoned order, in such a case the courts will exercise its jurisdiction under 226 to set aside such an order. where a case where there is a non-application of mind by the commissioner. So there is total non-application of mind by the commissioner in any order which is passed. In such cases also the court will interfere and will set aside those orders and pass appropriate orders. If any error is apparent on the face of record, if the commissioner has just failed to look into certain relevant arguments, some relevant provision of law, something which the SSE had relied upon, some document, and such a case where the mistake is apparent on record, in such type of cases also the courts will set aside the order of under 264 and ask the commissioner to exercise the jurisdiction properly. So in most of the cases when we challenge these orders, if it is passed against the SSE and we challenge these orders before the court looks into these basic requirements, and if you are able to satisfy, the courts interfere and set aside those orders and direct the commissioner to relook into the matter, unless the case is very crystal clear, covered by some decisions or the provisions, and there is no other doubt. The court also allows such type of application. There are also many cases, many a times the commissioner refused to condone the delay, so they just reject your application on the ground that you are coming beyond the period of 1 year and therefore the delay is not to be condoned, and they do not decide the case on merits. In such type of situations also the court comes to the rescue of the SSE, and they have said that hyper technical view need not be taken while dealing with such type of provision which are for the purpose of getting a right of an SSE to be addressed, which is the whole purpose of this section. In such a case, hyper technical views should not be taken and delay needs to be condoned, and the application should be decided on merits of its case. So on these grounds, the courts have entertained the petition and interfered with the orders passed by the commissioner under section 264. Let's also talk about certain duties and powers of the commissioner, though I have briefly dealt with it, but let me take one by one some points here. This will also help you while you are drafting the application. You can pinpoint these things or draft your application in such a manner that the commissioner will have to look into your application. He cannot ignore some of your grounds or your contentions. So there are certain duties and powers which have been cast on the commissioner. So he has a discretion to grant you a relief or refuse you, but while doing so he has to look into your application, look into your documents. It cannot pass an order in an arbitrary manner. He has to follow the principle of natural justice. If he is relying on certain documents or something which is not within the knowledge of the SSE, he has to provide an opportunity to an SSE before he passes such an order. Whatever he decides, it should be a reasoned order. It should be in accordance with the provision of the Income Tax Act. He cannot pass an order just to refuse to exercise his discretion, because I have come across many a time the commissioner just refused to exercise their jurisdiction under section 264 by just giving some flimsy reasons. That cannot be done. They have to, once the application is moved, they have to deal with that application. They have to pass an order dealing with all the arguments of the SSE. The contentions which are raised on merits, he has to exercise. He cannot refuse to exercise revisional powers on some vague or fanciful grounds. And the commissioner also needs to keep in mind, while exercising its powers under section 264, he has to see that ultimately a justice has to be done. He has to understand the purpose of behind this provision is to avoid miscarriage of justice. At the same time, he has to see that a justice has been done with the SSE. So while interpreting this provision or while looking into the claim of the SSE through this application under 264, hyper technical approach should be avoided by the commissioner. The approach of the department should be that yes, if a genuine claim has been there and it has been missed out for certain reason, the claim, if otherwise allowable, should be allowed, and other consideration should not come in the way of the SSE to raise this claim. So as I said, that even if it is a mistake of an SSE, even if a SSE has committed a mistake, in not making a claim or making an improper claim. Such type of mistakes should be ignored, and it should be decided on merits whether the conditions of other relevant provisions are satisfied, and if it is so, the relief should be granted to the SSE. So as I explained that as there are mistakes by the SSE, at times there are errors and mistakes which are committed by the assessing officer also. Again, such type of errors and mistakes which are committed by the assessing officers also, a 264 will lie, and the commissioner can exercise those powers and give a remedy. The commissioner cannot pass an order asking that why you have not gone in appeal, or you should have gone in filing a rectification application, or if their claim has been missed in the return, he cannot just say that why you have not filed a revised return and make the claim. He has to look into the claim from a different way, that yes, if this relief is been entitled to an SSE, that relief should be given to an SSE subject to the other conditions of the act have been satisfied. So he needs to overlook all those hyper technical approach while deciding an application under section 264. But at the same time, he has to see that the provision of Income Tax Act has to be followed. He cannot go beyond the provision of the act while granting a relief to an SSE. So there are certain direct decisions of Bombay High Court and other high courts where the courts have said that the SSE should be granted appropriate relief and without standing on technicalities. So hyper technical, as I've said repeatedly, hyper technical approach should be avoided when you are dealing with section 264 application. Similarly, in one of the cases where the Gujarat High Court has said, where the commissioner had refused to allow a claim to an SSE in one of the cases of high tech analytical services 402 ITR 479, the commissioner has rejected the claim of the SSE on the ground that the SSE should have filed a revised return, and as he has not filed a revised return, his claim cannot be looked in. An assessing officer was justified in restricting the claim in absence of a revised return. The courts had come to the rescue of the SSE and said that even if there is no revised return filed by the SSE, the commissioner should examine the claim of the SSE on the basis of the application which have been filed and the evidence which have been led, and thereafter, if needed, the inquiry should be made, and if the SSE is entitled for the claim should be allowed. Similar views have been taken by other high courts also. The courts are also you must all be aware of the decision of Goats India. So one can say that there is some conflict of views between Goats India and just now what I have referred to certain decision. So one has to understand that Goats India was in a different context, and what it had said that basically a claim which is to be raised before an assessing officer, it cannot be by way of a letter, it has to be by way of a revised returns. Though the decision is, I would say that the decision which is rendered was on a peculiar facts of that case before it, and thereafter also courts have interpreted referring to this decision and say that yes, this particular decision will not come in the way of an SSE or to the powers of the appellate forum. So if you are before a tribunal or before a CIT appeal, you can raise a claim, and that claim will be entertained, and Goats India really will not come into the way. The Goats India decision is more particularly if you are raising a claim before the assessing officer without any filing a revised return. So in such type of situation, the decision which I had referred earlier of Gujarat High Court will come to the rescue of the SSE when you are filing an application under section 264. So one needs to understand the difference between when you are exercising the power under section 264 as well as when you are going in the appellate forum and raising a new claim. So the remedies are at both ways. As I said, you have to see your facts of the case and decide where you have to approach. A classic decision on 264, if somebody is really interested in understanding the whole background and of this 264, one should read the decision of Parikh brothers, which is reported in 150 ITR page 117 of Kerala High Court, wherein it really explains the scope and power of a commissioner under 264, and it is a really good decision where it explores the provisions of section 264 and say how this power needs to be looked into and exercised by the authorities. So as I explained you that different situations where the courts can exercise these powers, and the authorities how the authority should act while looking into such a type of application. So there was a decision in the case of Nirmala L. Mehta. So this was a decision where of Bombay High Court, Nirmala L. Mehta versus CIT 269 ITR page 1. Again, this is a very classic decision. One should read this decision because it has many facets of legal principle under taxation. Here was a case where an SSE had offered some prize money which he had won in lottery from a Sikkim government, and he had offered this for taxation, and he had paid the tax. And later on, when he realized that this amount was not chargeable and accessible to tax, he raised this claim by way of a 264 application before the commissioner. The commissioner rejected its application on the ground that, see, you have yourself offered this particular income, and therefore I cannot entertain your claim. And he said that because you have yourself agreed, I will not be able to look into this claim. The SSE challenged that order and before the High Court, Bombay High Court, and the court, after analyzing the whole provision, they say that the estoppel will not come into the way. There cannot be an estoppel against a statute. If a particular income is not required to be taxed, it cannot be taxed merely because an SSE has offered that particular income. The court also referred to Article 265 of the Constitution, and it says that no tax shall be collected or levied without except by authority of law. So merely because a SSE has agreed for offering some income, it doesn't mean that the state, being a welfare state, it doesn't mean that they will collect that amount and they will keep it with their kitty. It has to be returned, and they cannot even keep one single naya paisa, which is against the law, with them. So, so wherever there is no authority, there cannot be any levy of tax or even a collection of tax. So another good decision where one can look into it, and these decisions, if required, if the commissioner at the time of your hearing, when he has to give you a personal hearing also, you can insist on asking for a personal hearing. In case these types of situation arises, you can use these decision to make commissioner aware about this provision, because to my experience, many a times when we appear in these matters, the commissioner also blank as to how the powers are need to be exercised and how they need to approach in such type of matters. So these are the few decisions, landmark decisions, which you can use to appraise them about their powers which they have and how they can exercise their power for granting a relief to an SSE, subject to other condition being satisfied. So there was one more case. I am just giving you certain live examples also, just to make you aware how this provision is really acted upon for the benefit of an SSE. So there is another case, in the case of Denny Densopa versus CIT, which is reported in 46 DTR page 129. Again, this is a Bombay High Court order. Here was a case where the SSE had offered certain dividend and interest income. SSE being a resident of Sikkim, these dividends and interests were exempt from tax for that particular region, and this was done through a retrospective amendment. So SSE had already offered. You rarely see a provision where an SSE has been given a benefit from retrospective effect, and that to an exemption provision. But this particular there was certain exemption provision which was given, and that particular class of income was not liable to be taxed. This amendment which came retrospectively, the SSE for last 8 to 10 years had offered this particular income. Few years assessment were completed under 143.1, no appeal, no further proceedings. Some were completed under 143.3, no appeal, and no further proceedings were pending. In such a situation, when this came, the SSE had come and they thought that what is the remedy now, how I can claim back my, because I have already offered and the assessment or the intimation has already been issued. On the advice, they filed the application under section 264. They applied for condonation of delay, and basic reason for condonation of delay was the retrospective amendment which had come, and from the date of retrospective amendment which had come, the SSE and within no time had approached the commissioner by filing the application under 264. So one of the reasons given that the cause of action had arisen after the amendment, and therefore really the delay which is there in filing the application for the last 8 years is should be condoned, and the application should be decided on merits. And on merits, it was a very clear-cut case that there is an amendment and this particular income is not required to be offered. The commissioner somehow refused to condone the delay and act on that, and against such order we approached the Honorable High Court at Bombay. The court looked into the matter and they said that one is that the delay needs to be condoned because the cause of delay has arisen because of the retrospective amendment. It is not a fault of the SSE, and in fact if the benefit legislature has given for retrospectively, then SSE should be entitled to claim that retrospectively also. There is no point that you bring a retrospective amendment but the SSE are not able to avail that benefit. So the court at the first instance condoned the delay. The court at the second saw that this provision is clear. There is no dispute about the claim of the SSE, and therefore the court went ahead to allow the claim of the SSE subject to verification by the assessing officer. So here was a one case where we had seen that the courts were so that they had allowed the application of the SSE where it was a crystal clear case, and the SSE got the relief for last 8 years against the income which he had wrongly offered for tax. So these are the few, and there are many such examples. I am just selecting few examples to demonstrate how the courts are looking into these claims and these applications when we reach to the High Court against the orders which are not allowing our claims. So this is how the court looks into this provisions. So the commissioner, while deciding your application, cannot ignore the binding decision. He has to follow. So if you are relying on certain decisions which are directly on the point by the jurisdictional high courts, they have to follow that decisions and grant the relief. They cannot refuse to follow the binding decision. So the principle of law of precedent is equally binding on the commissioner even when he is exercising the provisions under 264. So as per the discussion which we had, it reinforces my view that the nature of proceeding under section 264 is a quasi-judicial nature. However, while disposing of this application, he has to apply all the principle of natural justice. He has to decide the application judiciously. He has to follow the rule of precedent. He has to recall the records and look into the records before deciding the appeal. He cannot refuse to interfere on any ground which is flimsy or taking some hyper technical view. He cannot do so. He has to pass a speaking order dealing with all the contentions. So according to me, this is something, some provisions which one should really look into in a genuine cases where the SSEs are not entitled or the other remedies are not available to an SSEs. Friends, this is how I end with the first topic of section 264. In case there are some queries on this, I will like to take it before I take up the next topic under 119. Selva, are you there? Monica?
Yes, sir. Monica is here, so I'll share my screen, sir.
Yes. In case there are some queries, so I can take up. Yes.
Is my screen visible, sir?
Yeah, you are. I am able to see from point number 4. If you can, yes. Whether department can go for an appeal on an order passed. As I explained you, there are no appeal provisions which are there. The only remedy is there against an order passed under section 264 to go in a writ petition before the High Court. So yes, the department can go in a writ petition before, and in case they find that the order passed against 264 is something totally wrong. But to my experience, I have not come across any such situation where a department has challenged a 264 order before the High Court. So it will be a very rare instance where the department will go against the order under section 264. Second query is that on an order under section 264, can the SSC go before ITAT or only High Court? As I explained, it can go only to High Court. It is not an appealable order. There is no appeal provided against 264 order. So the only remedy which is there with you is to go before the High Court under Article 226 by way of a writ petition. The third question is that an income tax return was filed at the time of migration from manual to computerization. We have the manual acknowledgement. A series of letters were made and of no avail. The department say return could not be traced and could have been missed. No further action followed by the department. Your comments, please. As I said that this order, as I read also that under section 264, you can go in a case any order. So where is the order in such a case? There is no order in such a case. According to me, your remedy against this should lie on an administrative side. If the department is not commenting, you may write to the higher ups, and even to the board. You can approach the board also under 119. So my next presentation, which will be on the provision of 119, probably for this question number 3, you can exercise the remedy under section 119 and approach the board. But though this is an administrative problem, my advice will be that you write to the higher ups or along with all the evidences and inform that they are not taking any action, and if not done, you may write to the board also. Question number 4, whether SSC can go for an appeal after. I have already answered the same question. Number 2 has been here rejected by CIT after application is 24. Is question number 5, what is the jurisdiction of commissioner? Oh, sorry. Question number 5, what is the jurisdiction of the commissioner under 264 when all returns and orders are from CPC Bangalore? The jurisdiction will be the territorial jurisdiction of the SSC. Question number 6, so wherever the SSC is assessed, there you have to file your application under section 264. In case of the SSC who is a jurisdictional commissioner before whom the application is to be filed, as all returns are filed with CPC Bangalore and order under also passed by CPC, still your jurisdiction for all said and purpose, the CPC is processing your return, and your jurisdiction for all said and purpose will be your jurisdictional assessing officer, and to that jurisdictional assessing officer, whichever commissioner lies, you have to approach the jurisdictional commissioner for making an application under section 264. Question number 7, what is the difference between 154 and 260, as both appears to allow making fresh claim or rectification? No, there is a wide difference between both. 154 only is for rectification of mistake, which is apparent on record in an order. As I explained you, 264 is just not for rectification of a mistake, but it is also something which, for example, as I gave you an example, that you have not made a claim at all. There is no, in your return you have just missed to make a claim, or in a return you have wrongly offered a claim. that cannot be a mistake apparent on the record of in any order. That is a mistake in your return. There is a difference between when we talk of section 154, which talks about mistake in the order, and here there is no mistake in the order, there is a mistake in your own return. So these are two different situations. You need to appreciate that the provisions of 154 of a rectification in an order, and when the mistake is in our return, we cannot say that there is a mistake in an order, the commissioner has not granted you a relief. So there is a difference between. So 264 are quite wide enough. Further, 154 has a very limited jurisdiction, whereas 264 has a very wide powers and jurisdiction to decide a matter. They can decide that particular issue, look into your claim, look at your records, and thereafter decide that. So the powers under 264 and 154 to my mind are quite different and will be exercised in a very different jurisdiction. Question number 8, refund cases. Transfer the case to jurisdictional assessing officer. Transfer the case to the jurisdictional AO. AO takes the view that the return e-filed for refund is non-est. Transfer a case to jurisdictional AO. AO takes the view that the return e-filed for the refund is non-est. SSC filed 264 revision in January. Till now, commissioner has not decided about the case. Is there any time limit for commissioner to decide? As I said, subsection 6 of 264 provides that on an application by an SSC for revision under this subsection, an order shall be passed within 1 year from end of the financial year in which application is made for revision. So again, the word is shall be passed, so it is not something very mandatory. Maybe because you had filed it in January 2019, I think so you should remind again, and if there, you can send a reminder to the concerned principal commissioner or the jurisdictional CCIT for this. Is the process of revision under section 264 offline currently? I think so. In each region, you have to see. As far as Mumbai is concerned, during the last year also, I had attended 2 matters which were on offline mode, and we have attended. So it depends upon how the concerned region takes up the matter. I had attended offline in just last few months back. A charitable society audit report filed belatedly, but ITR filed on time. Denied 11 exemption and tax. What is the remedy? To that effect, I think so there is a remedy which is provided by circular number 6 of 2020 for condonation of delay in filing the return or filing form 10B. So you have to exercise that remedy rather than going to 264. You can exercise 264 also, but there is a specific remedy wherein this delay in filing this form has been condoned for assessment year, I think so 16-17 and 17-18 and onwards. So you can refer, there is a circular number 6 of 2020 according to me, which addresses your query in this regard. So you can look into that also. Question number 11. What is the order under 264 is not, what if the order is not passed within 1 year from end in which petition is filed? As I said, the section talks about shall pass. So it is not that if he doesn't pass, anything will happen. It is more a directory provision. So you can insist, again, write and to ask them to decide. You can write to the higher ups. You can approach the concerned commissioner and you can raise your concern over non-passing the order for which the SSC is suffering, and may request him to dispose of the matter at the earliest. 119 versus 264, which route is better for an omission of claim of deduction having tax effect of 2 crores? Sir, this is more a factual question. There are certain claims which are overlapping. You may choose 119 and 264. It depends on facts of each case. We cannot have a generalized. During my talk also, I had repeatedly said that while exercising these remedies, you have to keep in mind what is your facts of your case, how the case can be looked into it, whether there is also requirement of some other grounds, other documents. So the appellate forum is quite wide. The remedy there is a different 264 in that context is a very different jurisdiction. So it depends on facts of each case, in what context this claim of deduction you want to raise. It depends upon all that. So when you are going in 119 also, it is not that in each and every case you can just go and claim any deduction or so and so. So there are various other factors which you have to keep in mind before you exercise either of the remedies under 119 or under 264. So it will depend. It's a more of factual aspect. Question number 13. How many more questions, madam? 13. One of my clients, a private limited company, field.
17 questions are there, sir, actually.
How many more?
17 questions are there, sir, actually.
Okay,
5 more.
okay. Chalo, let me deal with that. We have time, so let us go through this. One of my client, a private limited company, failed to claim the benefit of concessional rate of tax. Intimation under so and so is there. Can the SEC file an application to enable the claim of concessional rate of tax? Now, if you go to the regime of concessional rate of tax under 115 BAA, there are various other conditions also which you are required to fulfill. I am not aware whether you have fulfilled those conditions. Subject to that, you can make an application under 264. But if for the rate purpose you are just going and you just say that I have missed to pay, the better course should be that you filed a revised return if time permits. If the time is not available to you, you can go to the CBDT under 119 and ask for condonation of delay and accept your revised return. So the better remedy would be that. But there again, you have to explain out your case, what has happened and why your application should be looked into it. So once your delay is condoned and your revised return is accepted, that return will be processed and whatever rate of tax you are there, but subject to the conditions of 115 BAA to be met. Can we explore the remedy under section 264, delay in filing form 10 IC for availing lower rate of tax? So and so, it is a similar question what I answered. If there is a delay in filing form 10 IC, really a question will be there that it is merely a matter of delay, but can the whether the provision under the act allows the officer to condone that delay. If the act doesn't allow the powers to condone the delay, really the commissioner will not be able to go beyond the act to give you some relief. So the better remedy will be to approach under 119. Is there any time limit for decision by the commissioner on section? No, the 119 is exercised by the board and the board delegates this power to the commissioner. I have to deal with 119, but before that only questions have come. So the time, there is no direct time limit, but they have to decide within a reasonable time. I have seen that 119 applications are pending for 2 years or 3 years. Prior to that, it was pending for a longer period, but now at least they are deciding in the period of 1 year to 2 years. Form 10C, again the same question. 16 is the similar question what has been raised. I have already answered. Can section 264 application be made for requesting revocation of withholding of refund under section 241 made with the intimation? Yes, you can try to do this. 17, can we file a revision application for non-filing of form 10? This is the same question which you have missed, so you can try it out under section 264, but the better remedy will be 119. There is no bar also. Let me add here, there is no bar that once you approach under section 264, you cannot approach under 119. So there is no bar, vice versa. But the correct approach here, as there is for filing this form, there is no direct provision under the act to condone the delay. So the correct approach can be to approach the CBDT to condone the delay, because they have the power to do so, and their powers are quite wider as compared to the powers of the commissioner. So they have more powers and they can do so. Okay, Monica, we have done with this questions.
Yes, as of now only these questions are like raised, sir. So
Yes.
I'll stop sharing my screen, sir, and we can go for the next.
Yes, if there is something, you can let me know at the last, after the end of this session.
Yes, yes.
I can take them also again once again.
Definitely, sir. Definitely. If it is repeating also, you can omit it, sir.
Yes, no problem. But if you there questions are there, I'm okay to take it again at the end.
Now,
Okay.
as of now, these were the questions, sir.
I will move
So,
to the next
yeah.
topic, 119. So basically, there are two limbs in section 119. Though the more concerning and relevant for the topic is section 119, subsection 2. But as we are dealing with this provision, let me deal with section 1191 also for some time, for the sake of completeness also. And as far as the new professionals are there, it will give them an idea about this provision also. So basically, the highest executive authority for direct tax matter is Central Board of Direct Taxes, which is constituted under the Central Board of Revenue Act 1963. And they have basically the power of supervision, administration, and control over the whole department, income tax department. It has power to issue orders, it has power to issue instructions, notifications, directions, circulars, and all this they exercise under section 1191 whenever they require. However, the act provides that while doing so, while exercising this power, there are two limitations and two restrictions which are there, which they cannot do so. One is that they cannot interfere with the discretion of the CIT appeals in exercise of their appellate function. And the second is that they cannot direct any income tax authority to make an particular assessment or to dispose of a particular case in a particular manner. So you need to understand these two provisions very thoroughly. These are the restrictions which has been placed by the legislature. This also means at times that the assessing officer, when he is deciding an assessment, he is supreme. He is the final authority. The higher ups cannot direct him that, look, you decide this particular case in this manner, or you assess a particular class of income in this particular way or this particular manner. Same, he cannot interfere with the power of the CIT appeal. This is more to show independency of the authorities while they are doing the assessment or they are deciding any appeal of an SSC. So the boards can issue powers, general powers, circulars, instruction, which can give direction to the all income tax authority how to approach in a general manner, but they cannot be specifically say that a particular assessment has to be done in a particular manner, nor they can interfere with the discretion of CIT appeal while dealing with any appellate forum. To this reaffirms, basically this provision reaffirms the independency of the assessing officer as well as the first appellate authority. You need to also see that in one of the decision in CIT versus Green World Corporation 314 ITR page 81, the Supreme Court has while dealing with a complex issue was referring, and they have made a passing remark that the assessment order passed on the dictates of an higher authority is wholly without jurisdiction and it's a nullity. So if a higher authority has passed an order on the dictation of a higher authority or on the direction of an higher authority, the order itself is null and void. So the Supreme Court also has reaffirmed this and said that the assessing officer should be totally independent when he is doing an assessment, and nobody should interfere with his discretion and powers to complete an assessment. Friends, you will be recollecting that there was a central action plan of 2018 and 19 which was issued, and there it provided that the CIT appeal will receive certain incentives if they enhance assessment, strengthen the assessment order, and or levy penalty under 271(1)(c). This was the wordings referred in this Central Action Plan of 1819. This move was condemned by various professional organizations across the country, and all the leading industry representatives has condemned this action it had come in various newspapers. It was a matter of discussion before various forums, and all the tax professional had condemned this type of, saying that how can you give the incentive to a commissioner appeals to see that they pass an order of enhancement and confirm levy of penalty, and this amounts to interference with the powers of the commissioner while disposing of an appeal. In this case, the Chamber of Tax Consultants had filed a petition before the Bombay High Court, where the Bombay High Court decided this petition, and which is reported in 416 ITR page 21, where the court said that this observations has to be deleted. It is not in accordance with law. You cannot pass such type of you cannot give such type of incentives and pass such type of directions which will amount to interference with the independency of the first appellate authority. So a similar observations you will also find which is made in the case of Sripur paper mills by Supreme Court way back in 1970, 77 ITR page 6, where they say that the CIT appeal is a quasi-judicial authority, and there cannot be any interference by the superior authority in the judicial work or a quasi-judicial work of the authorities. So this is how the independence of these authorities had been reaffirmed by courts time and again, and this is how this particular provision has to be looked into it. Now coming to section 119 subsection 2. Basically, section 119 subsection 2 gives a power to the board to issue circulars, orders, instructions in order to see that the work of assessment, collection of tax, etc. is being carried out properly. Okay, so and these instructions should not be prejudicial to the SSC. So they cannot. So many a times you might see that we challenge the circular saying that it is contrary to the provision, it is adding something new in the provision. So such type of circulars cannot be issued. They can issue the work for efficient management, for the purpose of proper management, collection of revenue, proper work of assessment, allocation, etc. They can issue. They can relax also any provisions, give relaxation orders also. So during COVID period, there were many circulars time and again which were issued giving certain relaxation to the SSC. So these were done under these particular provision. So this particular provision, subsection 2, subclause A, basic is that in public interest, in interest of public, at times they can issue such orders, directions, where the SSC can be given necessary relief. This order can be for a class of incomes or particular class of cases or class of an SSC also. So it is not necessary that a class of income should be wide, or it may include a particular class also. A class of SSCs may also include very few in number. It is not necessary that it should be large. However, whenever this directions are issued under subsection 2 clause A, it has to be in the interest of public interest, and it should be, the purpose should be for proper management, work of assessment and collection of revenue. The applications what we make as an SSC we make to the board is normally coming under section 119 subsection 2 small clause B, which is relevant for our discussion purpose. So let me read this subclause. It's a small clause, but everything, once you read this, everything is coming out of this clause. So let me read this clause for the benefit of everyone. The board may, if it considers desirable or expedient so to do for avoiding genuine hardship. So please keep certain words in mind when you are reading this particular provision. The board may, if considers desirable. So if it is not compulsory, if it considers desirable or expedient to do so, avoiding genuine hardship in any case or class of cases by general or special order, authorize any income tax authority not being Commissioner Appeals to admit an application or claim for an exemption, deduction, refund, or any other relief under the Act after the expiry of period specified by or under this Act for making such application or a claim and deal with the same on merits in accordance with law. So if there is some claim, exemption, deduction, refunds, or any other relief under the Act where there is certain limitation period which is provided, and you have failed to make that within that particular time period, you can make this an application under this provision to the CBDT to condone that delay and to admit your application to be decided on merits. However, you have to also read along with this the first limb of this particular provision, that the board may, if considers desirable. So it is purely a discretionary power which is given to the board. I understand that this discretionary power has to be exercised in a judicious manner, and not in an arbitrary manner. The further condition which is there to avoid genuine hardship. So when you are reading this provision, you have to keep all this thing together and you have to read. There has to be a genuine hardship. It is a discretionary power of the board. So you have to make out your case where you can say that yes, this discretionary power which is vested in you should be exercised in the favor of the SSC because of the following hardship the SSC is facing, because he could not file its claim of refund, for exemption, for deduction in time prescribed under the Act for so and so reason. Once you are able to satisfy, the board may accept your application and direct the authority to decide your case on merits. So most of the application that we make for anything is falling within this particular clause B subsection 2 of section 119. So let us also see few further notice and clarification which are issued under this particular section wherein the powers are exercised. So at times the board, when this provision has been enacted, the board had found that there are certain times certain difficulties which are faced in a business by an SSC on various accounts, and therefore it was a policy decision which was taken that the government and the senior officers felt that in certain type of these circumstances certain exceptional powers should be given to the board, and the board should be given a discretion to exercise this power in genuine cases subject to fulfillment of other condition. And therefore this administrative relief has this power to grant this relief has been given to the board. The board at times have delegated this power and authorized its officers, mainly the principal commissioner or the chief commissioner, to exercise this delegated power and to pass appropriate order while dealing with such type of an application. So so in a case where the belated claim of refund is there, so in that case, if you have missed to file your return of income, you can approach the board and to make your claim. Let's take another case. There is a loss return. Your loss will not be allowed to carry forward if your return is not filed in time. In such a case also, if you have a genuine reason, you can make an application before the board and say that for following reasons you were not able to file your return in time. You have to explain, justify that, and you can make this application before the board, and the board, if considered your case to be a genuine case, they will condone the delay, direct the officer to accept your return. Once your return is accepted and the delay is condoned, your loss will be allowed to be carried forward. So similarly is the case of a refund also. So these are the few cases where we see most of the applications which are made are coming under this category before the board, and the boards have taken a favorable view wherever you are able to justify your reasons for the delay in making the claim and justify your hardship also before the claim. So the courts have taken a view that the board can relax the rigors of law for grant of relief, which is not to be found in the terms of the statute. So such circulars make for just and fair administration of law. So this is how the courts have looked into these provisions, and so therefore, in order to see that the tax administration is harsh on a particular SSE who for some genuine reason has been unable to claim its deduction, exemption, refund, or file its return in time, in such type of cases, the board may will exercise its discretion in the favor of the SSE, subject to SSE making the applications and fulfilling the other condition. And therefore, also I consider this provision again a benevolent provision, because it gives a beneficial remedy to an SSE where its rights have either been expired under the act, or he is not able to exercise or fulfill the condition because some certain genuine reasons. In such type of cases, this provision comes to the rescue of the SSE, and the SSE can avail this and get its claim, deductions, or exemptions revived before the officer. Always it will be subject to verification of the claim and subject to fulfilling the other conditions of the relevant provision. So the courts have also, as I said, has said that it will be appropriate for the authorities to consider and relax the provision of law in genuine cases to avoid and prevent genuine hardship to the SSE. So the power exercised by board in this subsection is again a quasi-judicial power. The board can issue the power in respect of any class of SSE or a class of income. So it is not necessary that it should be for a great, even if one SSE is entitled to that and he makes that application, this particular relief cannot be entitled. So again, this circular in this particular provision cannot be adverse to an SSE. It cannot affect the SSE in any adverse manner. Either it will give you a relief or it will not give you a relief, but it cannot affect you in any adverse manner. And the decision given by the CBDT is again binding on the authorities. The authority cannot challenge that order before the court or in an appeal or anywhere. Once the board gives you an instruction, the assessing officer is bound to follow that instruction and grant the relief. There cannot be a challenge to an order which is passed by the board. One needs to keep in mind that the legislative provision cannot be amended by the CBDT in exercise of power under section 119. So you cannot go and ask for some relief which is totally contrary to the Income Tax Act. In the grab of 119, again, the CBDT cannot exercise wide power than what has been given to them. So the CBDT powers has to be restricted to what has the provision has been provided. They cannot change the income tax provision and grant a relief to any particular SSE beyond the power what has been granted to them. So one also needs to read the provision, the circulars which are issued in this context from time to time. So one of the circular which is issued is dated 26th June 2006 for waiver or reduction of interest. So wherein the powers has been delegated to the chief commissioner by the board and the principal commissioner to the extent of certain monetary claims. And this case is there that where the cases where an waiver application for waiver of interest can be filed before the board, and this will be looked into subject to fulfilling the condition. So in cases where if you are able to fall within the circular limits, within the conditions set out in the particular circular, you can prefer an application before the board for waiver of interest. So one of the classic example here within the circular itself, which is given, is that any income which is chargeable to tax other than the capital gain, where the waiver application, where any income which is not chargeable to tax under because of some decision of a higher forum, and later on it happens that that decision is reversed, and now the SSC has to pay the tax. Let's take a classic example, is that the recent decision of freebies to doctors which has come. Now this decision was earlier in favor, now it has been reversed. In such a situation, an SSC is liable to be taxed. So in such a situation, the clause C of this circular comes to the rescue of the SSC, where it says either the interest has been levied because of any retrospective amendment, or because of any change in law due to the decision of the Supreme Court, or by any larger bench of any jurisdictional high court. In such a cases, if there is some demand or levy of interest is there, you can make an application and satisfy that it is a fit case for reduction or waiver of the interest. Also, in the cases where the return could not be filed by the SSC due to unavoidable circumstances, and such return is filed voluntarily by the SSC or his legal heirs without detection by the assessing officer, but there is a levy of interest, in such type of situation also you can make an application for waiver or reduction of interest. So this is just a example in regards to one particular aspect where this circular has been issued. So if you are falling in within this class, you can approach the board for waiver of interest. Similar guidelines has also been given for waiver of interest charge under section 2011A of the Income Tax Act, which is circular number 11 of 2017, dated 24th March 2017. So there are various circulars which are issued from time to time for each aspect. So if you are falling within any of the class, you can have to refer to this circular, satisfy the condition specified therein, and then you can approach. One of the very interesting case which is sub judice before the court right now was a case where the SSC had approached the BFR, and pursuant to the scheme which were not approved, but they had made that application and the approvals were pending, the BFR board had not decided. The SSC had acted on that scheme which was there, and the lead bankers were there in that. On the basis of that, they had repaid their creditors, and all the other outstanding, whatever was there, they had tried to clear. After 5 to 6 years down the line, when the matter had come up on the board and it was to get the final approval of the scheme, the BFR itself board was removed, the CICA Act was no more applicable, and all the cases, and that was said that it will now, the matter will be looked into by NCLT subject to other condition being satisfied. Unfortunately, this SSC acted on that basis. On that basis, it had borrowed money from its subsidiaries and sister concerns. On the premises, they had made certain application for waiver of certain taxes, also capital gain tax, etc. And all this he had done. Now, because of the change in the law itself, he was in a situation where he had to pay the taxes. His demerger scheme couldn't finalize pursuant thereto, which he had planned that after this would have done, he would have entered into such type of arrangements. He was not able to complete and fulfill that because of the change in the position of law. He had to pay the taxes. As far as the levy of interest is concerned, he at least said, he approached the board and said that this is a case because of change in law, nothing was there in my hand. The proceedings was on its way, but because of change in law, the things were not finally done. In such a situation, at least he should not be saddled with the liability of payment of interest. The board referred to the circular, which I just referred of 2006, and they said that we have very limited powers. These are the 3 to 4 sub clauses which are given. If your case falls within this, I will be able to give you relief. Otherwise, our hands are tied. And they rejected my application. The matter is pending before the court now. where we have said that even if the circular didn't provide it, the board should have exercised the power in such a case and should have granted the relief to the SSE, because this is a genuine case, and it is because of the change in law which has happened, the SSE has to bear this liability, and therefore the application could not have been rejected merely on the ground that the circular which has been issued delegating the powers to the commissioner doesn't the claim of the SSE doesn't fit in that circular. It doesn't mean that the claim should be rejected. This was a case where the board should have exercised its power by saying that yes, whether this SSE is a genuine case and whether it should be exercised, the power of waiver should be exercised or not, because the original power was vested with the board, which had delegated with certain direction to the lower authorities, which is still pending. So there are certain times, certain very peculiar cases where we can approach the board and ask them to interfere in the genuine matters to give grant relief to a SSE. So let me also deal with some instance where the courts have interfered in the matter and they have allowed the claim of the SSE. So there was a case of Pala Marketing Cooperative of Kerala High Court, where the condonation, the return could not be filed on time because the delay was not account of the party, but because of the certain audit was not completed. And if the delay would have not been condoned, there were certain refund claims which were there, which would not be allowed to the SSE, and there were losses, something it was there, and all these issues were involved in that case, and the SSE was able to satisfy that the delay was not on his count, but because of certain external factor which he could not have controlled, and it was beyond his control. The court entertained, the board rejected its claim, and when the matter reached to the court entertained the claim and said that this is a desirable case where the board should have exercised the power of condoning the case, and should allowed the board should have allowed the application, and the matter should have been remitted to the AO to decide. On the basis of the application filed, the court allowed the application of the SSE and directed the assessing officer to look its claim on merits of the case. Similarly, in this regard also, for condonation of delay in filing refunds claim, there is a circular number 9 of 2015, which is dated 9th June 2015, where again it gives certain directions for claiming condonation of delay in filing return, claiming refunds, and claiming carry forward of losses, set off, etc., to be looked into by the officer. Here again there is a jurisdiction which has been set depending upon the monetarily claim, this which is 10 lakhs before the principal commissioner, up to 50 lakhs before the chief commissioner, and beyond that it has been delegated to it has been kept with the board. So this, subject to fulfilling the other conditions, the claim of this can be entertained. So one has to go through this circular, and on particular instance the SSE can approach the board for condonation of delay. There are different types of cases. Sometimes there are floods, there are some particular region, some particular accident or some incident has happened because of which the return could not have been filed in time. In such type of cases, one can take the benefit of this provision and this circular and make the claim before the respective authorities. So the Bombay High Court has entertained in the case of Yash Society 163 DTR page 337. The court has entertained an application for condonation of delay in filing the return and claiming refund of TDS. So here the court dealt with all the other criteria and said the CBDT has not dealt with the contentions of the SSE and the specific evidence which had been led by the SSE, and therefore the order of the principal commissioner was set aside and directed to deal and consider the parameters which were set out in the circular and to decide the claim of the SSE. So, similarly, refusal to condone the delay by the board also for a refund of claim of TDS. The court has said that you don't have to adopt a hyper technical view, but you have to allow such claim considering that the case of the SSE, you should allow the claim and allow the refund of the to the SSE. There was similarly a case was there before the Bombay High Court in the case of Bombay Mercantile Cooperative Bank, 332 ITR page 87. Here what happened, being a cooperative society, they have to also get an audit done by under the Cooperative Society Act of the state of Maharashtra, and therefore the RBI appoints certain bankers. The panel is there, and the cooperative department thereafter assign these auditors to the respective SSE, pursuant to which the appointment of the statutory auditor under the act was delayed. By the time when the officer was appointed and he had to conduct the audit of various branches of the bank and file the report, the timeline had already expired, and because of which the SSE was not able to file its return in time and make the claim of the refund, and the losses also something was there. On that basis, when the SSE approached the court for condonation of delay, the court took a view that look, the delay is on account of late appointment of the statutory auditor, and therefore the delay should be condoned. It was not the mistake of the SSE. On that basis, the delay was condoned, and the SSE's return of income was taken on record and directed to the assessing officer to look into the matter of refund. Similarly, courts have taken that there is, in the cases of delay, always there is some minor lapse on the part of the SSE, but the court should, the officers of the department should not take a hyper technical view. They has to see the genuineness of the case and see what how the wrong can be set right, and the claim of the SSE should be allowed in that aspect. So that is how the courts have looked into these claims. Discretion to admit a claim beyond a period specified in exercise on the so and so, like one day there was a delay of 1 day in filing the return because of some technical lapses in the site. The courts have taken that this cannot be treated as a mistake on the part of the SSE, and the SSE cannot be suffered because of technical snag in the website of the department. So this is a because nowadays lot of changes are there in the website and all the portals and everything. This decision is of Madras High Court in CBDT versus Region Infrastructure and Services, 389 ITR 138 Madras High Court. You can take the benefit of this. The only thing is that whenever such type of snag happens, you should keep a record of this, and so that you are able to show to the authority that on that particular day this was the issue which was involved, and because of which you are not able to file the return of income on time. Now friends, just broadly, if you have understood the claim and what sort of claim can be looked into and entertained, there is one aspect which always the court asks is genuine hardship. What is genuine hardship? So the genuine hardship has to be, there is no fixed criteria defining what is mean by genuine hardship. So really the genuine hardship, courts have taken a view, has to be interpreted and looked into on a wider perspective. So genuine hardship for me might be different, and for a particular SSE might be different. So when you are seeing genuine hardship, one should have a closed mind, but it should have a very open mind and see from the point of view of an SSE. Financial hardship can be a genuine hardship. Okay, a genuine hardship may be a peculiar business of an SSE who is suffering during the last 2 years. We all have seen, due to COVID, a particular class of business and various type of small business houses have suffered a lot. So that can be a reason of genuine hardship. As present what we are facing, this can be a good reason of genuine hardship, and how the courts can look into it. So these are the few provisions where the court looks and interpret this provision, which always depends on the facts what you make before the board. When you are filing an application before the board, you should bring out the genuine hardship, your claim, why there was a delay, or in case you want some benefit, why this benefit, and how the other condition has been satisfied. You have to give a background over the SSC, explain your past history, give the relevant documents, so that the board will exercise the discretion in your favor after going through these documents. In my notes which I have circulated, I have given certain incidents, other nature, the decisions which are there, which you can go through at your convenience. In my slide, I have also given a small note on the circular of 1955, circular number 14, dated 11th April 1955, which was a beneficial provision, and at that time the legislature had thought on this and had issued such a circular. Today, many times, most seniors who are present, if they might be aware that whenever we cite this circular before the officers, they say, "Arey, it is of 1955, and today now we are in 2020 and thereafter 22." Therefore, this circular, whether it carries any weight, the act is changed. Earlier, this was 1922, now it is 1961. But I will tell you that I have referred in my note that today also courts have, relying on this circular, have given benefits to the SSC. So you can refer to this circular, cite these decisions, and ask that yes, this officers and this has to exercise the power in the favor of the SSC where there is a genuine case. Just because of the ignorance of the SSC, or because of misinterpretation of any fact or law, if any claim has been missed, the department cannot take the benefit of this and cannot deny the claim to an SSC. It is a duty which is cast on the assessing officer and these authorities to allow a claim, to give a claim a benefit to a SSC if he is entitled to. He cannot take the benefit of the ignorance and of the SSC. As the principle is there, there cannot be an estoppel against law. So you cannot stop from an SSC from making a claim merely because he has failed to make a claim in the return, or he has raised a claim contrary to the law. There is a decisions I have cited where the courts today also are relying on this circular and granting the relief. So if the department or anybody says that this is an old circular, not applicable, this is contrary to the law, it is not so. Today also courts are relying on this circular for granting various relief to the SSC in various different circumstances. So friends, I have tried to cover up most of the aspects and important points in this particular provision. I can take up some questions also. There is still some time, so I can take up the questions. Monica, if you can share this your queries.
Is my screen visible, sir?
Hmm.
From 19th question we need to take, sir.
Okay, from 19, when foreign tax credit under 16 is due, so can we appeal this way? If the credit has been disallowed, if I understand, if this credit has been disallowed, there will be some reason for it. If there is some reason, the correct way should be, if you have the appeal remedy, you should exercise the appeal remedy, because there you can argue, you can cite. If there is a diversion of view, then there more scope will be there for you in an appellate forum. When we are going in 119 or under 264, the view should be very crystal clear that the claim or the rights of the SSC should be crystal clear that they are entitled to you. If there are diversion of opinion, there is no point in going in this direction, because the officer, if exercise a view which is contrary or which has two views, then in such a situation the remedy against that particular order will be a high court to you, whereas in an appellate forum you have still the tribunal which is left for you. So depending upon the facts of this case, you may decide. 20, a very longish question. A non-resident who returned to India in beginning of the previous year due to health reason received all his salary from company abroad in his bank account of India. Of course, TDS was made by the foreign company as per their tax laws and known as tax as you pay as you earn. The SSC disclosed both salary and TDS under respective head while filing the return as not ordinary rates, and during this period the TRC was not implemented. However, the AO taxed the salary but conveniently ignored the TDS as it did not appear in 26 years, setting a huge tax liability on the SSC. Several rectification requests were in vain. Is there a remedy available? If he has ignored, you can go for 264, cite all these things. Just see that your claim is very clearly met. You can exercise 264 in such type of situation. 21, whether application will be made for denial of 80IB deduction owing to delay in filing a return. So yes, you have to file an application for condonation of your delay in filing the return before the CBDT. Once your return delay is condoned, automatically your 80IA deduction will come into play. Monica, can we just slide down a bit? Scroll down.
Yes, sir. Yes, sir. 1 minute.
This 22 question is not yes. Yes, please. SSC missed to file the income tax return for financial year where he had as a refund, and the reason for that was he was not aware of the compliance. Not sure what exact reason can we give to PCIT for application to be made. Yes, you can file an application under 1192. As far as the reason is concerned, I cannot provide you the reason. It will depend on the facts of the case. You have to speak to your SSC and make this application. When you are making this application under so and so, attached the necessary documents. If there are certain factual aspects, I will advise you to attach a affidavit of the SSC also to that effect. 23, section 12A, registered society had wrongly filed the result resulting in disallowance of exemption. Now it has time barred for all limitation due to wrong filing. What is the relief available? Condonation or apply to CIT appeal based on merits. If the order is filed, the society has wrongly filed the return resulting in disallowance of exemption. If the appeal remedy, you are within that time and the time it is time barred also, I think so the remedy more suited, depending what you have said, is the CIT appeal. Make an application for condonation of delay and go to the CIT appeals on time. So rather than going for 119, it may be further, because wrongly your return is, I understand your return is filed on time, but there is some wrong filing which has been done. So depending on that, my advice prima facie seems that you can go to the CIT appeals with condonation of delay based on your merits of your case. Question number 24, while pending the condonation application with the CBDT for condonation of delay in filing audit report, the faceless assessment completed without considering the pendency CBDT condonation, section 11 exemption denied and tax on surplus income on so and so, and penalties. What is the remedy? If your condonation application is pending with the CBDT, please write to the CBDT that such type of action has been taken and to decide your application at the earliest. At the same time, you inform the concerned assessing officer about your pendency of your application with the CBDT. So once the CBDT passes an order, automatically your other requirement will be discharged, and automatically the penalty or so and so whatever has been done will have to be rectified by the assessing officer. So you may write to the CBDT again and remind them for passing the order at the earliest. And your audit report in form 10B is not there. I had referred that there is a circular to that effect. Some circular number 6 is there, and there is one more circular to that effect. Kindly look into, and recently also some circular and judgments have come on this point. So kindly look into that and make your claim before the CBDT. Are there any monetary limits for application under 119 by the SSC? There are no monetary limits, but all the application has to be made, but the board has delegated the powers depending upon the quantum of claim. So to the extent of 10 lakhs, the principal commissioner is authorized. To the extent of 50 lakhs, the chief commissioner has been authorized, and below 50 lakhs, the claim is looked into by the CBDT. So like that, the claim has been set by the monetary limits has been set. So depending upon your claim, you can file. If there is a overlapping of jurisdiction, or you are not very clear about where the jurisdiction will lie, it will be advisable that you send your application one set to the CBDT by registered post only, and not by private courier. Send it to registered post to the CBDT chairman. File a copy with your regular commissioner as well as to the assessing officer, asking them to send your application to the appropriate authority who is entitled to deal with your application. So kindly you can do that. Can the High Court against an order under 2 say to give effect to the order of the High Court to the AO and do not grant interest on refund due? Is it correct? I am not able to understand this question. Can the High Court against the order under 264 can say to give effect to the order, of the High Court to the AO and do not grant interest on refund due? Is it correct? I am not able to understand this query. If you can reframe the query, please. By the time I will take up the next question. Under new income tax portal, how can we make application under section 112B? Whether any separate form? No, there is no separate form. There is no, you have to file it manually with the CBDT chairman. If you have the email of the CBDT chairman during the COVID, it was allowed to be sent through email to the CBDT chairman also. As I said, what is your monetary jurisdiction? Depending upon that, file a copy with your jurisdictional assessing officer as well as to the principal commissioner. If your claim is up to 50 lakhs, you can approach the chief commissioner also of your jurisdiction. No appeal against section 119. Does this mean writ petition cannot be filed? There is no appeal under 119, and therefore only writ petition can be filed against an order passed under 119. 29. We have preferred revision application under 264 failure to submit form 10 IC as the AO has not considered upon exercise the so and so in IT return. Under this situation, can we go for application under simultaneously? You can file that application, but while filing the application, do mention about your revision petition being also filed at 264, but the same has not been looked into it. And you can also mention that either of the authority may be directed to deal with your claim and decide the matter. So kindly make the disclosure about the other application also filed before both the authorities. 30. Dear sir, order received from Commissioner Appeal condoning delay in filing the return and allowed refund, but instruction to ITO to verify refund claim and allow. What is the time limit for ITO to grant refund from the date of Commissioner order? Should the SSC follow up with the ITO, or he will pass the refund if the SSC approve the payment of taxes? I don't know first how the Commissioner Appeal can condone the delay in filing the return. Commissioner Appeal do not have power to condone the delay in filing the return. So I am not able to convince with this sentence. And as far as your time limit is there, the assessing officer has to pass an order in accordance with section 153. That is, I understand, 1 year from the date of end of the financial year. He has to pass an order giving effect. So if he has to pass an order giving effect, depending upon that, the refund has to be granted. 2031. Gujarat High Court holds SSC at liberty to seek CCIT permission under so and so for belated filing of so and so. Rajkamal Harar so and so. Yes. So as I said, that you can seek that permission under 119 for belated, but the application is under 119. So you have to make that application and seek the permission from CCIT permission. So that is what Gujarat High Court said. But as I said, you have to file your application under section 119. Whoever the power has been delegated will look into the matter. As for example, as I explained regarding the late filing of form number 10, form number 9A in case of a charitable trust, the powers were specifically delegated by the CBDT to the concerned principal commissioners, and they were exercising. So you have to file the application, and wherever they delegate the power, you can go there and claim the benefit. Question number 32. Can it be scrolled down a bit? Yes. ITR for AY 1415 and E filed on so and so. CPC, upon knowing that return files result in refund, transfer the file to the jurisdictional AO. AO took the stand that IRE filed is non-est. SSC filed condonation petition. Commissioner has not decided the condonation petition for last 3 years. What is the remedy upon the SSC? You give reminders, try to find out whether the petition is still there, or they have just not received, or they are not acting on that. Kindly remind them, send a reminder to the CBDT also. In case they don't do it here, then the remedy will be, or you don't receive any response, then the remedy is that you have to go to the court asking them a writ to be passed, directing them to dispose of your application within a reasonable time. But before going there, be sure that your petition is pending somewhere, because I have come across few cases where the SSC's case was that I have filed the petition, and when I said that where is the acknowledgement, they had informed that it has been sent by a private courier. And when the question came that what is the acknowledgement, courts and these authority do not recognize private courier. So whenever you are making this communication, you are sending it, please do send by registered post only and not by private courier. Secondly, see that your application copy, one copy should always be sent to the CBDT chairman also, which will help you at a later point of time, that maybe at times the overlapping jurisdiction is there, the jurisdiction many times it is very confusing and you are not very clear before which authority your application will lie. At such situation also, your claim cannot be rejected merely on the ground that your application is not found to be filed before a correct forum or authority. So do file your petition before the CBDT also, before your concerned jurisdictional commissioner, and at time before the AO also. And you can put a line when you are filing before the AO and commissioner that to place the matter before the appropriate authority. Remedy in case where rectification under 152 is not disposed of within the limitation period of 4 years. There is no, if they have not disposed of petition, you have to, they cannot exercise that power within that 4 years. Your remedy, if at all, will be a writ jurisdiction, or you have to approach the higher ups before that. Once the time limit has gone, they cannot exercise that power. If you consider of going to 264 or 1192, you can try it out there. I'm not sure whether they can provide. Yes, 119 has a wide power. Whether they will be able to exercise that or not, I'm not very clear, but you can try it out. 34, petition under 1192B of personal condonation of delay in filing return and rejected that reason not satisfactory. What are the reasons for allowing condonation? Sir, it is a very factual aspect. I cannot tell you what are the reason, but a reason something which appeals to a person, a reason where it is not smacking a malified intention, it is not a reason which is fanciful, it is not a reason where a common man conscious will not be moved in your favor. So try to get the actual reason what it happened. It might be it is just a mistake of the SSC, his ignorance, but try to get the reason and just not try to borrow the reasons. My advice will be that. And what is the remedy on rejection by principal commissioner, time limit, and whom we should approach for condonation? Once the petition has been rejected, you have to approach the court for condonation by way of a writ. We learned about both could be parallel pursued. If IIT application is rejected due to absence of genuine hardship, is it possible to pursue 264 now? Essentially, this means we are approaching the same commissioner under different section. Once you are doing this, you may be cautioned that if he has exercised under one provision against you, it will never exercise in the other provision in your favor, unless the one provision he has exercised the power saying that I do not have the power to grant a relief. For example, if you have approached the commissioner in 264 first, the commissioner may refuse to entertain, saying that he cannot grant you that relief because this power is not vested in him. In such a situation, you can approach 119, but it is advisable whenever you approach, there is no point in approaching simultaneously, but whenever you approach, you have to disclose the fact that you had made an application before the other authority and the same has been rejected for the following grounds. It is not that simultaneously you try to claim under both the provision. It is not a correct advice to approach them simultaneously under both the provision. few of my clients who has income about 2.5 lakhs and income below, since there was no income tax payable, we had not filed his return, but now he wishes to file the return. He has paid so and so tax fee. In some cases there are genuine reasons. It can be done. How it is to be done under present scenario? Online in IT portal or manual? It is manual. I have not seen that there is any portal on the online portal where you can file this application, so you have to file it manually. General hardship is one. If the general hardship courts, I have cited certain decisions in my article. Sir, please, if you can go through it, where the genuine hardship has been explained in different circumstances. As I said, we are dealing in a fiscal legislation. One of the genuine hardship courts have also took a view that in one of the cases of Sancheti, by name Sancheti, where I think so it was a Bombay High Court decision, where they have taken a view that even financial hardship will amount to a genuine hardship. So in a given facts of situation, you have to raise a genuine hardship in a case where a company has been in making losses, and somewhere or the how they have survived. It can be a claim which of loss or refund. If it is denied, it will be a genuine hardship in that case, where these are not been allowed. Also, you need to keep in mind that there is an instruction number 13 of 2006, which has subsequently been amended to 2015 also. In 15 also, that circular has been further amended, where it restricts the claim should be made within 6 years from end of the relevant assessment year. So whenever you are making such application, you should also keep in mind the time limit which is provided in this circular. Again, this time limit is in the circular, and not, there is no such time limit in the act which has been provided. So Monica, I've done with the questions.
Yes, sir, we are done with the questions.
Okay.
Please.
Okay. So it was a patient hearing before all of you. I really enjoyed taking this technical session, and it was really an honor and pleasure for me to speak before all the learned participants. And thank you, Monica, Naresh ji, and all Selva and all the other office bearers for giving me this opportunity to present this paper before all of you. Thank you very much.
Thank you so much, sir. Thank you so much for your time and for your patiently like accepting our invite for today's program, sir. Thank you so much, sir.
Bye.
Yes, sir, we'll end the session. Thank you.